Dani. I am the CEO of AFSA. I have the privilege of I had prepared a speech, but I don't think there's enough time for that anymore. I'm going to just say one or two things that I thought was important, that I think is important to say. I promise I'll be like 30 seconds. On behalf of AFSA, it is my great pleasure to welcome you to this important gathering titled Efficiency in Arbitration, Balancing Fairness, Time and Cost. We are honored to host this event in partnership with our esteemed colleagues from Penson Mason, Herbert Smith Freehills, Comba, HKA, and the Chartered Institute of Arbitrators. Today's topic strikes at the very heart of what modern arbitration must deliver. Not only outcomes that are just, but a process that is timely, proportionate, and cost-effective. As arbitration continues to evolve, the imperative to balance efficiency with fairness is no longer a nice to have. It is indeed a necessity. It is what the users demand. It is, in fact, what our legitimacy as institutions, practitioners, depend upon. So on those few words, with those few words, I welcome you all to AFSA, and I'm going to hand over to Andrew, who's going to be moderating today's discussion. Thank you.
I think we've got these mics, Andile. Thank you. Thanks, Andile, and good evening, everyone. To everyone in the room with us, welcome, and to everyone joining online. I believe there's over 200 or something online, so welcome to you as well. If the IT people are still there, a few of you might have noticed that there was a QR code on the screen earlier. If I can ask them to just put that back up again for 2 minutes and ask everyone to scan the QR code so that you can access the Slido app. We're going to be doing a few polls and posing a few questions to those in attendance to get your views as to this very interesting topic. While we replace one of our speakers' face with the QR code, let me just maybe introduce myself. My name's Andrew Fawcett. I am a partner within the Construction Advisory and Disputes team at Penson Masons. My main focus predominantly being in dispute resolution within the infrastructure and energy sectors, which includes both domestic and international arbitration. I'll be moderating this evening's panel discussion. It's an interactive discussion. We welcome input from the audience, questions, and there will be questions at the end that you can pose to any of the panelists. And the format really is just to be a bit of a discussion between all of us as panelists to have a free-flowing engagement on this interesting topic. I've already mentioned the QR code, so I'll skip over that and get into the topic today, which is delving into the intricate balance, as Andile said, that needs to be struck between fairness and efficiency in arbitrations. It's not only fundamental to the integrity of arbitration proceedings, as being a cost-effective and expeditious form of alternative dispute resolution, but it's vital in ensuring the parties are actually satisfied that their dispute has been resolved and that justice, in as broad a term as that is, has been served and has been seen to be served. Fairness is a bit of a nebulous concept, but it encompasses, principles such as natural justice, procedural fairness, the right to be heard. In the arbitration world, these principles are normally manifested through the empowering legislation or the rules that are agreed between the parties and which thereafter bind the arbitrators. However, at times, and in particular, we'll talk about some experiences in this, perhaps the fear of being perceived as not being fair can often bring about challenges in maintaining the efficiency and the cost balance, and which makes the cost effectiveness and what makes arbitration such an attractive form of dispute resolution, being efficient, somewhat challenging. The parties' legal reps, but perhaps more so the arbitrator, are generally tasked with the responsibility of conducting these proceedings and balancing this fine balancing act. And the arbitrator is generally afforded a very wide discretion in this regard. Jonathan will talk us through some of the rules and the ambits, and we'll frame that up right up front as being the sort of starting point for this discussion. The balance is crucial. Inefficiencies lead to prolonged proceedings and significantly increased costs, even more so in the arbitration world where you're paying for your venue, your transcribers, your arbitrator's time, lengthy experts generally, or lengthy experts, Tim, experts, witness statements, and it can undermine the very purpose of arbitration, especially in, personally, my personal view is that there really shouldn't be a world where you're having part-heard arbitrations, which just, double up the costs when everyone has to come back in a couple of months' time and reacquaint themselves with the issues. So we're going to be discussing these sticking points and what hampers efficiency, and maybe put together some practical suggestions as to how this balance can be struck, which could include, more proactive case management, the use of technology, better forms of taking evidence, better forms of framing the issues, and really the full utilization of the powers that are afforded to an arbitrator to regulate this process. I am just the fly half tonight. I'll be posing the questions to this panel, and maybe I should introduce themselves. We can now replace the QR code with Abdul, who is one of our panelists joining us from London. Abdul Latif Janaidu. Abdul is based in the UK. He is a barrister at Keating Chambers. He specializes in construction, engineering, and energy disputes, as well as UK domestic and international arbitration. He has an extensive international practice, both as counsel, dispute board member, adjudicator, and arbitrator, and his practice predominantly focuses on the Middle East and Africa. Joining me here in the room, a number of familiar faces to you all, I'm sure, but in case you need a reminder, Jonathan Ripley-Evans. He's a partner at Herbert Smith Freehills Kramer. He's based in the Johannesburg office and heads up their South African disputes practice. He has extensive experience in both domestic and international alternative dispute resolution. He is an AFSA accredited mediator and arbitrator and a fellow of the Chartered Institute of Arbitrators. He was a member of the core drafting committee responsible for the revision of the AFSA international rules, which were launched in 2021. And he's currently the vice president of the AFSA International Court, as well as sitting as a member of the Court of the Lagos Chamber of Commerce and International Arbitration. So the room is Henk Lowe, practicing advocate in South Africa and a member of the Law Society of Lesotho, holding his chambers at Rivonia Group. He is an arbitrator, adjudicator, and mediator, and he is a fellow of the Association of Arbitrators, a fellow of the Chartered Institute of Arbitrators in the UK, and a fellow with Prime Dispute also in the UK. He chairs the Chartered Institute of Arbitrators South Africa branch, and he serves on the Society of Construction Law Committee and the AFT Mentorship Committee. Finally, Tim Harwin. Tim is a partner at HKA and is based in Cape Town, or now based in Cape Town. He's a civil engineer with 23 years of construction industry experience. He is a delay expert witness and has prepared expert reports and given expert evidence in multiple arbitrations around the world. The astute listeners among you may pick up on his Australian accent. Don't hold it against him. Having realized that the Wallabies were no good at rugby and seeing the untold potential of the Springboks, he has made the wise decision to relocate himself and his family to South Africa. And so we welcome. He's been in the country 2 weeks. Before we kick things off with a bit of a discussion, I think maybe let's gauge the mood of the room and where you all feel this issue sits. And if I can put the first question up on Slido, and I'm going to pose the question, it'll also be on the screen, and you'll be able to vote on it. The question is this: in my experience, arbitrations are as efficient and cost effective as they could possibly be. Let's see what the mood of the room is on that issue. Well, this is, I think, quite a telling response there, is that the vast majority think that they could be more efficient. I think that's something I tend to agree with myself as well.
But Andrew, perhaps we can, the 22% who think that arbitrations are efficient should be sitting up here, and they can perhaps educate us all.
Explain how. Okay, let's move on to the next one. And this one, we're not going to have a poll, but I'm just going to ask some suggestions here. And what, in your opinion, are the biggest factors impacting efficiency in arbitration? Put one-word answers, you can put sentences, but we should start getting a theme that comes up around this issue so we can understand where the perceived sticking points are. I reserve my rights in relation to old arbitrators as a suggestion. Experience of arbitrators, costs, the rules, procedural delays, oral evidence, reluctant arbitrators, procedural paranoia, uncertainty regarding how arbitration is conducted, finance, some really interesting insights in relation to that, and I think mirrors a lot of what we're going to be discussing today. Use of the uniform rules of court, reluctant arbitrators, knowledgeability of subject matter, postponements, delays. I think we get the general feeling around where this sits, and costs is a significant one, which I'm not sure if it impacts the efficiency, but willingness to compromise. Great. I think if we can then move on to some really interesting insights there, I think, and it's quite clear where the sticking points potentially are, or at least the perceived sticking points.
Well, that deals with my presentation.
So that's the end of the presentation. Yeah, I think that's brings us to the end. And then the last question: the tribunal taking a proactive approach to setting the timetable and procedure, rather than leaving it solely to the parties' representatives, would make a material impact on the efficiency of arbitrations. Either we've had one vote or there's overwhelming agreement. Give it another minute. But I think that's quite a telling poll result around the proactivity of arbitrators in really taking an active hand on the tiller, so to say, in guiding the process and ensuring the process, and not just deferring to the parties, so to say, because generally one party isn't in the as enthused about resolving the dispute as quickly as possible, and this is where we can really get into some stumbling blocks. I think that teases us up quite nicely into the discussion, and with that in particular around the arbitrator taking an active approach. We also saw that in the previous question as being a sticking point, and the use of the incorrect rules and the incorrect procedures. I think, Jonathan, maybe that's a good lead, and if I can start with you. As a starting point for this discussion, what are the arbitrators empowered to do? And perhaps you can just answer that question with reference to the AFSA international rules as an example. Obviously, this would apply across all procedural rules that govern arbitrations. But if you can take us through the AFSA rules, and what are the obligations and powers conferred on arbitrators to regulate this process, as we see is a common desire amongst everyone.
Thanks, Andrew. Really good to see so many friendly faces again. Thanks for coming out this evening. The topic today is an incredibly important one for practitioners, either acting as counsel, advising behind the scenes, or sitting as arbitrators. And caught in the middle of this is a tension possibly an uncomfortable topic to talk about. And that is driven by the way in which lawyers and arbitrators are paid for arbitrations. And when you're paid by the hour, you're not really motivated to do it as quickly as possible, to be dead honest with you. And that is a tension that we face as practitioners on a daily basis. And that is why the role of the arbitrator is that much more important, because you then have to rein in the parties who may not be acting in the best interests of ultimate clients at the end of the day. And I'm not saying that this happens all the time, but when legal representatives are paid by the hour, they're not really motivated to get done with their work very quickly. And I always see in practice, one way to really, really test something is you get people working on cap fees, or you have a reverse sliding scale, and I quickly resolve something, you make more money. Then all of a sudden things can be resolved very quickly. And so as an arbitrator, you really have that as a challenge to deal with. And if you just appreciate that tension, it does make some of the tricky decisions a little bit easier. But it doesn't diminish the importance of your role as an arbitrator. So sorry for going off topic slightly. Going back sort of to the foundational principles that we're dealing with right now, Andrew's mentioned the international rules. Before I touch on the rules, I just want to talk a little bit about the Act, because that's really where you would start with your mandatory binding principles. What are the obligations imposed upon an arbitrator? What are the powers of the arbitrator in terms of the legislation before we even get to the rules, which is essentially the contract between the parties? So if I can just flip through some of the principles that are largely repeated in the rules as well, and we'll just highlight those now as well, coming from the Act. If we start with Article 18 of the Model Law in terms of our new International Arbitration Act, I'm not going to be talking about the Domestic Act at the moment. That's a chapter for another seminar over 6 weeks. But we're just going to mainly focus on the international position. And the reason why we're doing that now, well, is number one, we've got the international rules, which are largely aligned with the international best practice. A lot of time spent getting those rules up to speed, but that's also where we want the future of AFSA to lie, in a consolidated process built around rules of that nature. If we start with Article 18, which encapsulates the equal treatment of the parties, the starting point there is treatment of the parties, not the legal representatives of the parties, and it's something to remember, because when you are going back and you're examining whether a party was treated fairly or unfairly, it's not whether the legal representative was aggrieved. Was the party deprived of some right that they would have had? Just bear that in mind, because Article 18 says that the parties shall be treated with equality and each party shall be given a reasonable opportunity of presenting his or her case. That doesn't mean you're entitled to do whatever your lawyer says you should do. And it's important to appreciate that as an arbitrator, the starting point is the parties, not the legal representatives. And all they're entitled to is equality as a starting point. So whatever you do for one, you do for the other. Equality applied both ways. And that the parties are given a reasonable opportunity of presenting his or her case. That doesn't mean presenting their case in the way that they want to present it. It's have they been given an opportunity to present their case? And I'm stressing that because that underlines everything. When we start looking at the tricky decisions, the tricks that are played and are pulled by counsel and legal representatives in an arbitration, you go back to your basic principles. You say, did that deprive the party of an opportunity of presenting its case? Yes or no? And if it's not, well, then it's not the irregularity that a party may want to look at. Just looking through some of the other provisions that I think are quite important. Article 19 deals with the rules of procedure. Starting point, as we know, the rules can be agreed between the parties. That's your starting point. That is the contract between the parties. If the parties do not agree on something, that is essentially where the arbitrator steps in and exercises jurisdiction. We always start and say, the arbitrator can control the process. Now, as a starting point, that's right, unless the parties have agreed otherwise. And sometimes that's forgotten by arbitrators. The starting point is the agreement between the parties. It's only if the parties haven't agreed on something does the arbitrator have free rein to do what he or she deems is appropriate. Popping down to Article 23, dealing with the statements of claim and defense. Now, this is also another topic for another seminar. When we're dealing with, and I think my colleagues will talk a little bit about memorials versus pleadings and the like. I'm not going to go into that right now. But one of the interesting points there in terms of the Act, the parties can agree in their agreement as to how they want to deal with the procedure, and then the arbitrator has to apply that process, and then the parties change their mind. And the Act itself doesn't have a presumption either way in relation to pleadings or memorials. But as we look at the rules just now, there is a presumption in the rules, which is very important to be aware of. So that's Article 23. 24, in relation to hearings, very important. Parties don't have an inherent right to an oral hearing. That's a starting point. In an arbitration, sometimes you'll find it's more efficient not to have a merits hearing, and the matter can be resolved on papers. So the starting point is generally the tribunal that has a decision as to whether to hold such a hearing or not. If the parties haven't agreed to hold a hearing and one party requests it, then the arbitrator is obliged to have it. So that comes down to the fairness point. So if both parties are neutral about a hearing, the arbitrator has the right to determine. But the moment that one of the parties requests a hearing, then the oral hearing must be given. Okay. Very interesting point on default. Article 25 dealing with default of a party. How does the arbitrator balance that fairness when one party refuses to participate? Well, you got your three examples. The one is the default in filing a statement of claim after the request has gone in. The arbitrator can determine that the proceedings are discontinued right there and then. If your respondent doesn't file its defense, the arbitrator is empowered to carry on with the process, notwithstanding the lack of that defense. But what the arbitrator is not entitled to do is to make a presumption that the lack of filing a defense implies concession to the claim. So the arbitrator still has to run the whole process. And then the third one is in relation to failure to appear at a hearing. Now, there's no duty on the arbitrator to not continue. If a party doesn't arrive, the arbitrator is well empowered to carry on with that hearing in the absence of a party. Okay. I think then let's quickly have a look at what we've got in terms of our new international rules for AFSA. I'm going to start in Article 10 because this is one of the provisions that was quite it was debated at length, slightly controversial, and that is for expedited procedure. Well, the expedited procedure, together with early dismissal, were probably the two most heated provisions that were included in the international rules. And the expedited procedure is still, as far as I'm concerned, underutilized. It is still something that can be used. It really has come out of practice because there is a need to get rid of unmeritorious claims, where you have people who are really just trying to kick the can down the road. Previously, there wasn't a mechanism to try and have an early dismissal. And importantly, this provision relates to both a claim and a defense. So either party can apply to basically find, in summary fashion, that the one claim is without merit. Important points about this Article 10, and please read it very, very carefully. You can only apply for it before the constitution of the tribunal, and it starts with an application to AFSA. That application is normally met with a response from the other side, so both parties have an opportunity to argue for and against the expedited procedure. The decision whether to refer the parties to an expedited process is taken by the court. So you'll write to Svetlana, she'll refer the question to the court. The court then will deliberate on the documents before it. The court will then decide whether to refer the matter to expedited proceedings or not. One of the interesting provisions there is if the parties have agreed, for example, to 3 arbitrators, the power of Article 10 is that the AFSA can appoint a single arbitrator. So that can override the decision of the parties. One of the reasons why it was quite hotly debated, because that overrides. But implicit in choosing the AFSA rules, you're agreeing that AFSA would have that power. It's very important. Then there are certain provisions related to timeframes. That's really pressure on the arbitrator to run that process as quickly as possible. That really is, dare I say, cheap and nasty process of resolving a dispute, because it really is focused on getting something done as quickly as possible. And the 2 requirements there, number 1, your dispute must be under $500,000 or the parties can agree. And the parties can agree up front. So you can put that into your DR clause in your contract ahead, and then it can be above $500,000. But there needs to be agreement or below 500,000. So very important provision, very helpful with driving efficiency in processes, underutilized, but we've still got a lot of learning to do because it is relatively novel in South Africa. I'm not going to talk about emergency arbitrators because that's not really affecting efficiencies, but it is a novel process that I think everyone should spend a bit of time going through. And then the provision that I mentioned a little while ago, the early dismissal. So the early dismissal and the expedited process, early dismissal, as I mentioned, it's available to both parties, so claimant and defendant, for dismissing a claim that is unmeritorious. So the requirements there, it's a claim or defense which is manifestly without legal merit. So it needs to be obvious on the papers that there is no claim there or no defense there on those papers. And then you can apply the process set out in Article 12. The next provision I'm going to talk about, okay, Article 15 deals with the powers of the tribunal. I suppose this is really at the core of what we're dealing with right now. And what you'll find with many rules around the world, so now we're dealing with procedural rules. Rules are drafted deliberately in a vague way. And the reason why they do that is because they don't want to be prescriptive and they don't want to limit the powers of the arbitrator. You'll see most of the provisions contained in Article 15 are empowering in a sense that they empower the arbitrator to take further steps as deemed appropriate in certain circumstances. Many arbitrators are not brave enough to take steps unless it explicitly says, I can ask for this particular document. They won't ask for it because there is this fear of review, fear of being challenged. And it'll take time for us to get through that. It comes from a position of confidence in your position. And dare I say, the easiest way to get confident in your position, get confident with the rules, study the rules, understand exactly what the rules mean and how they're supposed to be implemented. That's one way you can be confident that what you're doing is empowered by the rules. I'm not going to go through all of those provisions because most of them, as I've mentioned, are quite broad and they're not really specific. We're going to talk just now about the mechanisms and what we can really do to bring about, a very efficient process. But again, the one thing that I did want to flag under Article 15 relating to the powers, and that was sort of the corollary to the Act, and that relates to the power to conduct the process as he or she deems appropriate. And the corollary to that is there is a general duty on every single arbitrator. And that duty is to act fairly and impartially as between all parties, giving each a reasonable opportunity of putting its case and dealing with that of its opponent. And recall that that's very similar wording to the Act, talking about reasonable opportunity, not do whatever you want, reasonable opportunity. And then the second one is very important for what we're discussing today, is to adopt procedures suitable for the conduct of the arbitration in an expeditious and cost-effective manner, having regard to the complexity of the issues and the amount in dispute. Most arbitrators read that and say, well, that's not really helpful. It doesn't really tell me what I'm supposed to do. But it does talk about the key obligation. It's a general duty imposed upon the arbitrator. And arguably, if an arbitrator is not running the process in an expeditious manner with regard to the costs that the parties are incurring, they're not actually adhering to that general duty. And the parties are entitled to hold arbitrators to account on that point. I think I may want to stop there. That's the rest will come out in further discussion. Yeah.
On that, with a few sort of questions around how we do this and how we facilitate this. You spoke about the rules being specifically drafted in broad terms to allow for flexibility, and I'm not going to repeat what you've said around the Act and everything, but practically, how do we do this? I mean, you talked around the complexity of the matter and the amount in dispute being a factor. But you can have a very simple dispute for a lot of money and a very complex dispute for not that much money. How does the arbitrator go about, and I'm going to put this to the broader panel, so anyone feel free to chip in. How does the arbitrator go about actually making this decision and setting the procedure up front at the initial case management meeting? Where do we get this information from? We've obviously got the request for arbitration, which is going to give us some level of insight. But that's really the crux of it, because if you set a procedure or a timetable that is not sufficient for the complexity of a dispute, then you're going to result in part heards and knock-ons and requests for an extension, and that's when things start running away. So to the broader team, how do we get around getting clarity on that? Is it done prior to the case management? Is it done, through getting the legal reps to take an honest assessment?
And consideration probably is to have the proper arbitrator to sit with the rules, with the agreement between the parties, and have a knowledge of what the dispute is about, and then call your first procedural meeting, and then make a procedural order in the manner and methodology to run the matter and run it properly. Now, again, that's not, of course, in terms of what the parties want, but what is efficient to the parties in the process of the procedure, taking into consideration costs and efficiency in the process. Now, everybody talks about the issue of costs, and we saw just now that was probably the primary consideration of the parties. And the perception of the parties is generally, the minute that you've got to pay an arbitrator, you're in trouble. But what parties do forget, and we ran a discussion the other night with Sutherland, GJP, and an actuary, Greg Whittaker, and we asked him to model for us the whole cost issue. And at the end of the evening, we all walked away, and the thinking was, it's cheaper to arbitrate than it is to litigate due to time efficiencies, inflationary value of money, time value of money, etc. But to do that and to get to that point, you need a proper skilled arbitrator, possibly a professional arbitrator, that's going to take control of your matter and is going to make sure that through a proper set of procedural orders upfront, the matter is going to be run fairly and productively between the parties.
Got your hand up, but maybe you want to chip in as well.
Yes, yeah. I just, if I may, I can start by apologising for not being there in person. I had intended to be, but unfortunately, I just couldn't make it work with my diary. Just to add a little to what's already been said by Andrew and Henk on this issue, and just drawing from my own personal experience, both as arbitrator and as counsel, I think it's really important for the tribunal, whether it's one person or three, to get a grip on the matter very early on. So when setting the procedural order number one is the critical sort of foundational document in making sure that the rest of the arbitration runs properly. And in order to arrive at a proper procedural order number one, which properly reflects the complexity of the dispute and is appropriately drafted to make sure there's sufficient time, sufficient money, sufficient time for the parties to be able to have the arbitration run properly, it's important that the tribunal communicates with the parties to understand, okay, what's this dispute about? What is the most appropriate way of going about resolving this? And making sure that there is honest communication with the party representatives as to how much time is going to be required for each procedural step. It doesn't serve anybody to have overly ambitious procedural timetables that attempt to concertina a very complex dispute into a very limited amount of time. You end up in a position where you have extensions and going part heard. So it's very important at the outset, in my view, that the tribunal takes a proactive approach to this. And just referring back to something that was mentioned earlier on about the AFSA rules, the provision in Article 15 that places an obligation, a duty on the tribunal to make sure that, let me make sure I'm reading correctly, that it adopts procedures that are suitable for the conduct of the arbitration in an expeditious and effective manner. Now, you'll find that provision and similar provision in almost every institutional rules these days, basically boilerplate. But it's the fact that boilerplate doesn't mean that one should ignore it. It's actually, what it's doing is placing an obligation on the tribunal to come up with procedures that are as expeditious and cost-effective, a cost-effective and expeditious procedure for resolving the dispute. And that duty is imposed on the tribunal to make sure that it achieves that. So it's really important that that's very much at the forefront of the tribunal's mind in putting together procedural order number one. And it's important that's done very much at the outset and done in communication with and consultation with the parties.
If putting in front of a procedure or agreeing or setting a procedure that's going to facilitate cost effectiveness. I think there's a bias amongst dispute practitioners who grow up in the courts, around pleadings. We want to plead it out. You don't want to admit anything that you don't have to admit. You don't want to play your cards, especially as a defendant. And as a claimant, you put the bare minimum in because you don't want to put a skittle up. And maybe, again, the question to the panel is memorials versus pleadings. You know, I don't think that there's any room in arbitration for tactical pleading, and really there shouldn't be any tactical pleading in arbitration. And how do we go about doing that? Because while the rules may suggest memorials or present all of your facts and evidence, that's sometimes interpreted quite differently by arbitrators, which is just plead the basic facts and the evidence will come later. And you can you know, generally has wording around the facts and legal positions relied upon to sustain the case or the claim. So how do we do about it? Because, you know, memorials is going to front load a lot of the expenses and the cost in the arbitration, getting your experts and your witnesses and then putting the party's full case in. But you're going to have a handle on what the issues are a lot earlier, and you're not going to have any diligence. So memorials versus pleadings, any thoughts on that?
Can I maybe just start with what the AFSA rule says as a starting point on this point? So within the time to be determined by the arbitral tribunal, the claimant shall deliver to the arbitral tribunal and the other parties its written statement of case, setting out in sufficient detail the relevant facts and legal submissions upon which it relies, together with the relief claimed against all the other parties and all supporting documents on which it relies. Now, that was another provision that we debated quite a lot in putting it in here. And we saw the benefit in front-loading proceedings. Once you're asking parties to put their case, which is for and against, right up front, showing the documents, show us what you have right up front, you stand a better chance of working out what the issues in dispute are quite early on. And once you know what the issues in dispute are, you can work out how complex your dispute is and how much time you need. Without that, we've got evasive pleading. It's very difficult for a tribunal to try and work out how much time we need to resolve this, because I've got an evasive defendant here who doesn't really know what their defense is, but they're pleading absolutely everything, and we just don't know where we're going. So that was a deliberate move in the drafting by the drafting committee in trying to encourage parties to go more memorial, maybe more memorial light, but the point is you've got to put up your evidence, and I think that's the important bit, which is quite different to general high court pleading.
Just on that topic, John, you see a similar clause to that in a lot of rules. And the perspective of the arbitrator plays a significant role in how that is interpreted. Because if the arbitrator is approaching it from a pleadings perspective and that's what he's comfortable with, then that can be interpreted as being just your material facts that you rely on, you know, and akin to the high court rules, which says, you know, plead out your facts and the material documents that you rely on. Whereas if it's approached with a memorial mindset, then obviously it's interpreted a lot more broader. I want your whole case up front. Abdul, maybe throwing to you there. What's your view?
Yeah.
Internationally, where do you see this going?
I think, I mean, in my personal experience and over the last, say, 5 to 10 years, memorials have pretty much become standard in international arbitration. Very rarely are you going to find a tribunal that's going to order pleadings, unless there's a very good reason for doing so. And a lot of that depends on the culture from which the tribunal is picked, but by and large, in my experience, memorials have become pretty much standard, and there's a reason for that. I think because, as Jonathan mentioned, I mean, there is a benefit to all parties, to everybody involved in the process, of having people put their entire case up front. So you're putting your best foot forward from the outset, and the tribunal and the other side can see the whole of your case from the outset. Now, obviously, it has the downside, the disadvantage of front-loading costs, but again, that's not necessarily a bad thing, because it tends, in my experience, to encourage parties to start talking about settlement quite early on if they know they're going to pay. You know, they're in for a very large bill, you know, quite early on. So, anecdotally, in terms of my personal experience, I think memorials are pretty much now standard in international arbitration. Occasionally, you still get the odd tribunal that orders pleadings, but they are few and far between in my experience.
There's a bias, a subconscious bias in terms of pleadings. I think it's more a bias to conduct pleadings old style, and South Africa as a jurisdiction has been criticized in various writings from overseas to say that up until we got the 2017 Act, which now brought in the idea of memorial style pleadings, everybody reverted and still, in some instances, run matters in terms of the High Court rules and want short and sweet pleadings with admit, deny, confess, and avoid, which is absolutely unhelpful in the world of arbitration. I mean, I was acting in a matter the other day on behalf of a multinational, and the judge and arbitrator dealing with the matter said, "Well, give me your case, just add on your essential documents, and we can deal with the rest in discovery." At the beginning, throwing out the whole process of showing me your case up front, and that was unhelpful. That eventually resulted in the matter being set down for 2 weeks without witness statements, oral evidence up front, not knowing what the witnesses were going to say, the matter being postponed for another 3 weeks of evidence, and the arbitrator now being not available anymore.
Yeah.
It's just chaos. And if you can show the other side your case up front, you'll get somewhere.
No, I tend to agree. I think that there's absolutely no benefit where you're trying to resolve the dispute and only knowing what the issues and facts are when you've heard everyone speak for the first time, and then have to actually wait for the transcript and the heads of argument to narrow it. It seems like a bit of a no-brainer from my perspective, but that's because I've got very much an arbitration practice. So we talk about subconscious bias, I'll lean towards memorials.
Sorry, Andrew, can I just add, just for the sake of balance, I suppose, to put the argument for the other side. I don't necessarily accept, but it's an argument that's made very often. You hear the argument made in favor of pleadings that it's very often the problem with pleadings is that it locks the parties into a case very, very early on, and there is if a party then has to amend or develop their position, as we always do when you're dealing with a live dispute, it's more difficult because you had to put in detailed memorials supported by detailed expert reports, witness statements, which sort of put forward one particular case. If you then have to amend that, that's going to add the cost. I think my answer to that is yes, that's true, but that still doesn't obviate the advantages of having parties, of imposing the discipline on the parties to make sure that they put their case as fully as they can from the outset. If nothing else, it makes the clients, it makes the lawyers, it makes the experts have to think very hard at the outset about what their case is, and that has advantages. And from the tribunal perspective, the memorials set out fully what the dispute is between the parties. So you as a tribunal can get on top of that dispute early on. You're not having to wait until at the end of the process to get sight of the arguments that are run, the evidence supports that argument. So in my view, I'm a big proponent of memorials, as I've already mentioned.
The evening. So I'll move things along a little bit, and Hank, I'm going to put a question to you, and I'm going to ask you to put your arbitrator hat on to answer this question. But we've talked about a reluctance from arbitrators to put an active hand on the tiller and to really step in, and Jonathan talked around the starting point is what if the parties agreed, but in circumstances where they haven't agreed, the arbitrator does need to step in. And there is a positive obligation on them to conduct the process, in a cost-effective manner. So, why do you think there is this reluctance, and maybe it's a perceived reluctance from arbitrators to really take an active role in guiding the matter forward?
Can I take one step back, and say that when the parties appoint an arbitrator, that's probably the most important decision that they're going to be making in the arbitration proceedings. Because the person that they're appointing is now going to be in charge of the process, the procedure, and the outcome. And if you have someone that does not fit the profile or live up to the expectations, the parties are in trouble. That person that you're going to be appointing has to be a person with expertise in the field, expertise in the arbitration process, must be impartial, and there must be an absence of subconscious bias. And that word comes up in the whole time, it seems to me, in very many of these issues. What is also important is that Svetlana some time ago introduced me to the book Walter's Kluwer Publications by Neil Kaplan QC and Xian Bao. The title is quite interesting. So now you're an arbitrator, the arbitrator's toolkit. and everybody wants to be an arbitrator, but no one wants to do the homework and study one of these things and determine what they are to do and not to do. Because once you read this and you decide and you see where you're supposed to go, you know that you have to control the procedures of the arbitrator. And of course, as Jonathan says, you have an agreement between the parties, and there where it's open, you've got to take control of it. You've got to run the process. You can make sure that you run it effectively to get a final decision. And in the whole process, the parties have to walk out there and look at the arbitrator, and they must think that they have a proper decision, and you must have a positive impact on the parties in the manner that you run this thing. Now, where does this whole thing go wrong? And unfortunately, this thing does go wrong. You have arbitrators that now walk into the dispute and they don't pay attention to the legislation that's applicable, the act that's applicable, the arbitration agreement between the parties, the rules applicable to the process, and how the rule fits into the arbitration agreement between the parties. So once they're now in that process, the thing goes astray, and the arbitrator allows pleadings to go in without memorials. And at the end of the day, when he sits and he's about to hear the matter, he doesn't know what the matter is about or where he's going to go with the matter. So that first process of the arbitrator in not taking absolute control of the process is an issue. Now, in whatever the arbitrator does, he must be mindful of where he is and where he's supposed to go, and considering the parties, and as I've alluded to earlier on, the cost factor algorithm, because it's our obligation as arbitrators to ensure that when we get to the result at the end of the day, it must be a cheaper result than when we went to the high courts and litigated the matters in the high courts. And unfortunately, that thing goes wrong and goes astray. Now, why does it go astray? Because once the arbitrator steps into the role, he knows what he's supposed to do. And he knows what his powers are in terms of the rules, the domestic rules, Article 11, international rules, Article 15. And the rules are fairly open. Now, the wonderful thing, if you look at the rules, and you compare it to what's in the High Court rules, in 3 pages of the rules takes over the very many rules in the High Court. And within that ambit, and within the uncertainty in the way that some of the provisions are crafted, the arbitrator must now act and act properly. And this is where sometimes go wrong. The arbitrator would sit out and he would have absolute respect for party autonomy, not looking at the dispute and not looking at the interest at the end of the day, and giving effect to some degree to the way that the lawyers see these things. And in that whole process, the arbitrator sometimes steps back and he allows the parties to run the process and the procedure, even from the outset. Even from the first procedural meeting, the agenda is presented by the claimant, where the arbitrator should be the party in charge of that. And the arbitrator steps back because he has a problem at the end of the day. When this award is now to be enforced, there may be all procedural issues and reviews in terms of the manner and methodology in which he had conducted himself or not conducted himself. And if he had stepped over the mark, there could be perceptions of bias or accusation of bias, or accusations that there was no maintenance of impartiality and neutrality in the matter. And in the event of a review being taken or a non-enforcement of the award in foreign jurisdiction, the criticism then goes back to the arbitrator himself. And once the arbitrator is criticized for a successful review of his award, then of course there's institutional issues, appointing authority issues, party appointing issues, reputational issues and considerations to the arbitrator himself, and the perception being created that the arbitrator may have misunderstood the rules, may have misunderstood the agreement. So arbitrators would rather not put their own reputation at risk and not make a hard decision which is going to affect the process positively, but is going to lead to a review. Now, why are reviews in our jurisdiction so difficult and so dangerous? If you have a review within the process, you end up back in the High Court in the domestic sphere. I've had 3 matters taken on review. The shortest was 22 months before the matter came back, and the longest was 35 months before the matter came back. So until that problem in the High Court is stopped, the arbitration process has a problem. And we must, and the arbitrators seek to avoid having their matters go on review and being dealt with. Now, I think one of the biggest issues with arbitrators are arbitrators without experience, without knowledge, without training. And as I said in the beginning, everybody wants to be an arbitrator. But when you sit there, you must be sure that you can provide and deliver on that which the market wants. Arbitrators without confidence, without experience, would then adopt a less confrontational approach and is then likely to give over to the parties and allow them more than able counsel and elected processes and procedures, which suits them, but not the hearing, to have the upper hand. So once we deal with the process of arbitration, ensure that whoever appoints your arbitrator and whoever considers what is to be done with the arbitrator, select someone that knows what he's doing. Because if that doesn't happen, you're in a world of trouble.
I mean, our courts have a very, the jurisprudence is very robust around what actually entitles you to review an arbitrator's award. It's quite a strict threshold, very high threshold for the most part. But is the fear that it could just be caught up in a dysfunctional court system to delay everything else, and so I'm going to take that risk out? Or is the fear, I don't want to be taken on an ultimate review for exceeding, as you mentioned, perception of bias or allegations of procedural unfairness? Is it a practical one of, if I take the least contentious approach, then I'm actually going to resolve this quicker because I'm going to keep it in the arbitration world? Or is it, I just don't want to be taken on the ultimate review or have that one award taken on review, which is going to, even though the rules, as Jonathan's mentioned, are very empowering, and the Act is very empowering in terms of what it allows.
Well, the interesting thing is when these matters go on review, the Section 33 grounds of review are not necessarily always what ends up in court, and parties throw before the judges quasi-type appeals, and that wastes time and process. But I don't think that's necessarily what arbitrators are concerned of. I think it's more their uncertainty in terms of themselves, the process, and what they are supposed to or not supposed to do. And then they sit in a process where they don't want to take a robust approach, because the robust approach would negatively impact and affect them in terms of what parties may or may not do in appointing that particular arbitrator again, or institutions appointing that arbitrator, or the arbitrator just not having confidence to be robust. Because sometimes the arbitrator has to be robust. And if you're not experienced, you don't have the knowledge, and you're not aware of the pitfalls and the benefits, you're not going to make that strong decision where it is required.
I mean, Abdul, just bringing you in here, and if you can come with your sort of UK international perspective, you've sat on international tribunals, you've appeared before international tribunals, so it would be good to get a different perspective. Is this a concern, or what is the approach of international tribunals? Do they take proactive steps to really drive efficiency while maintaining fairness? Maybe just talk us through what you would say best practice internationally is in relation to this.
No, absolutely. I mean, in my experience, and I'm just currently sitting on a couple of tribunals at the moment, and it's international tribunals and international arbitration, particularly if you're appointed by one of the institutions, the ICC or LCIO, whoever. There is a pressure on you to run the process expeditiously and cost effectively. So there's a top-down pressure coming from the institution that's running the arbitration, and a bottom-up pressure as well, and that the parties have an expectation that arbitration will be run in a cost-effective and effective manner. So you're there as a tribunal, and you've got that pressure acting on you to make sure that you take steps that are not going to draw out the process, not going to make things more cumbersome, less effective, and just basic, simple things which are now sort of fairly standard in international arbitration. So having a chess clock for the oral hearing, having red fund schedules for disclosure, all of these basic tools are now standard, and the whole purpose is to make sure that you don't get into a position where parties are spending enormous sums of money just having long drawn out procedure for the arbitration, and they're not ending up in a hearing that's run crisply and effectively. You make sure that, for example, I mean, I'm currently working with some people from the CIR on trying to get the best out of expert evidence in international arbitration. There are, because of the different legal cultures that you get in international arbitration, there are different approaches to how parties deal with expert evidence. And in construction infrastructure, which is what I deal with, construction infrastructure, energy, the arbitration that I deal with, expert evidence can be the most expensive part of the process. And unfortunately, in my experience as arbitrator and as counsel, very often parties spend enormous amounts of money. I mean, talking about millions of dollars in getting expert evidence, which actually doesn't really help the tribunal, because the tribunal has not done the hard work at the outset of making sure that they properly identify the issues that they require assistance with in terms of expert evidence, and making sure that their experts produce reports that deal with those issues. So we are trying to, this group I'm working with, we're trying to come up with an international best practice of taking the best from all over the world to see how things are done, to try and come up with effectively sort of a guide to how you could do expert evidence in international arbitration. And it's a huge task, but hopefully we'll produce something in the next 6 months or so that they'll give parties a guide as to how you should try and get the best out of your experts. I mean, something as simple as having expert meetings. It's something that, coming from my background being practicing in the UK, that is a fixture of our court rules here, that the experts have to meet and try and narrow issues, find areas of agreement, identify areas of agreement, areas of disagreement, and produce a joint report. Now, in many parts of the world, that's just not done, because for a lot of parties, they have almost a proprietarial, not almost, but actually a proprietarial interest, in their view, in the expert evidence, and they're not willing to let their experts go off and discuss things with the other expert. So you end up with parties producing expert reports that are like ships in the night, passing each other. There's no meeting of minds on what the issues are. So all of those sort of fairly nitty-gritty, basic issues, basic procedural issues, basic procedural mechanisms are what you find in terms of best practice in making sure in international tribunals that are running arbitrations properly and effectively. And it's important that you make sure that, in my view, that you have a tribunal that's familiar with those processes and does its best to get the parties to implement those processes for the benefit of everybody involved in the process.
If I can perhaps come in from the expert point of view, and maybe Hank took a step back before, I'll take a another further step back and perhaps just define the role of an expert for those in the room who haven't worked with one in an arbitration proceeding. So an expert is not an arbitration expert. It's a person who comes from a technical background, whether it be an accountancy background or a quantity surveyor or an engineer, as I am. And so that person provides a role or performs a role within the arbitration proceedings, and they're tasked with providing an experienced opinion on technical aspects of the dispute. And so they're just asked to answer questions using their experience and their expertise on certain technical points. But even though they're instructed by one of the parties, or there may be two opposing experts, one on each side, instructed and paid by each of the disputing parties, the overriding duty of that expert is to the tribunal.
Sorry, Tim.
Their duty is not to argue the case. So it's they're brought in to provide an independent opinion on perhaps a concrete expert around why the concrete failed, or an accounting expert on the valuation of the shareholder valuation, etc. So they use their expertise to help clear up some of the technical parts of the dispute. And so you might think, well, their role in the dispute is just to answer a question. So how can they really influence the duration of proceedings? So they've got a limited scope, but they can, and in my experience, I've seen it quite a bit, adversely affect the speed of the proceedings. Maybe they cannot accelerate things, but the behaviour of those experts and perhaps their limited engagements they have with the tribunal, who their duty is to assist. And this is picking up on the point that Abdul just raised there, that the tribunals have access somewhat to these experts. The experts are tasked with helping them out, and yet I can't recall one instance in the 20 or so arbitrations I've been involved with where I have had a discussion with a member of the tribunal or an arbitrator until I sit in the box giving evidence. And so, not that should happen all the time, but in terms of getting something out of those experts to assist you, or taking up, I think Jonathan used the words that the arbitrators have provided powers under the Act. Hank mentioned that the arbitrators need to take control of the procedure, and one way they don't often take control of the procedure is utilising these experts who are being paid for by the parties, but they're there to help the tribunal. So yeah, I think that just to bring to life perhaps some of the powers that arbitrators sometimes don't use but possibly should. That's just an example, just from my role as an expert in the proceedings.
So, to picking up on that, I mean, working in the energy and infrastructure sector disputes, and expert reports can sometimes run to thousands of pages. I've done arbitrations where there were 12 technical and quantity experts across various disciplines on various aspects, from steel to cement to design to, it can be an immensely expensive task. And because of the technical nature of it and the forensic nature of what the experts do, it takes time to actually allow them the time to put together the appropriate reports. And then there's the time in having to digest thousands of pages of technical information. So what are practical steps or proactive steps that the arbitrators can take? You've mentioned coming in and meeting them early.
Sure.
Is the early engagement of experts upfront prior to preparing reports, is that going to be of assistance? Is it, the very fun sounding, but probably not, does it work? Hot tubbing of experts, getting them all in a room together and debating things in front and with the arbitrator. We often see from, and the legal practitioners will have their point of view on this, and the arbitrators will have their view. But as the expert, as the person who's actually trying to reach agreement for the assistance of the tribunal, what's going to shift the dial?
Yeah, I mean, I guess why do the expert opinions and the reports run into the thousands of pages? I mean, speaking from my own experience, usually an expert report might be 80, 100 pages plus perhaps the same amount in attachments. Should be, that's the magnitude for most expert reports we should be talking about. But what often happens, and Abdul said it just now, ships in the night expert opinion. So you'll have one You have one expert, he gives his opinion. The opposing expert, who's also a concrete engineer, let's say, gives his opinion. And then they exchange those opinions in the course of the proceedings. And then it turns out they've been asked two slightly different questions and they've gone about it two slightly different ways. So now the first expert has to deal with a whole new analysis and respond to that. And the other expert also has to do that, vice versa. So we've got this crisscross or ships in the night passing, and then they've got to somehow in this crisscross back and then find each other. And then ultimately with a joint report or a Scott schedule, which then tries to put a big bow around the whole, the various submissions. And if you have multiple experts, that can happen on multiple occasions. So the purpose of this early expert engagement, which is a term that's thrown around a bit, is not just to engage your expert early and get his opinion to help bolster your case or to help strengthen you. It's then also getting that expert to engage with the other experts, so we don't have this ships in the night situation. So it doesn't have to be, and so the reluctance is there that you're sort of handing your case over into expert's hand. He's going to give away the farm when he meets with the other experts. So that's where you just need to have a bit of trust in your expert that he's going into the room to agree, okay, we're going to look at the most important documents are these, and we need to both have access to those and place reliance on them. We'll agree at least which are the important ones here. The questions we're going to answer are the same questions, and I'm going to potentially look at it forward-looking or retrospectively, or how are we going to deal with this in a general sense to come up with our ultimate opinions. So just a few of those commonalities early on, establishing those, can avoid the 1,000-page situations, and then you don't have an arbitrator who's overwhelmed. That arbitrator can then host perhaps a hot tubbing session where you get the experts together, and he's got a good platform to host that session or to get what the answers that he needs. So setting it up for success from the beginning by just the mindset of the experts, but also the arbitrator getting involved a little bit to make sure that they're heading off in the same direction, not two completely different directions from the beginning.
Speaking from a personal perspective, I've seen that be very successful in some of construction disputes, where proactive approach from the arbitrator saying, I want early engagement of the experts, I want a joint report to be filed, agreeing on what the issues that the experts or the questions that the experts are being asked, and parties engage, experts engage, and you set your list of questions, and that's what the experts are going to go and do.
Yeah.
So, it then makes sure that everyone's answering the same questions, and also then shortens the duration significantly for the Scott schedule and ultimately the issues. And in that particular matter, two of the experts just agreed on everything by the end. And so, which leads me to my next point, and that's maybe as another proactive step, not just related to
Andrew.
expert evidence, but call them as witnesses and cross-examine them, because they'd reached agreement and they knew that they were ad idem as to what the root cause of the concrete cracking in that particular issue was. So with that in mind, it may be one for either Jonathan or Abdul or Henk around arbitrators taking a proactive approach to hearing duration. We've allocated 3 weeks for the hearing. That's it. That's the time that you allocated. We're putting 4 weeks for the hearing, whatever it might be. It's allocated 2 weeks, 2 weeks. That's the time you've got. There'll be no part heard, and keeping people to that. What are the views on that, or so-called chess clock system?
I mean, I think the real task for an arbitrator's perspective is to try and work out how much time you actually need for this particular dispute. Going back to our earlier point, you need to know what the dispute is, needs to be articulated. The more evidence that you see early on, you can give a more accurate estimate as to how long you need for the hearing. A lot of the times where you see pleadings and then you have disclosure, we haven't spoken about disclosure, which is another topic that we can go down. But when you've got all that strung out and then you're only filing witness statements closer to the hearing, chances are your hearing is going to be derailed, because you're only really showing your case much closer to the hearing when parties haven't really prepared themselves. You're forcing the parties to front load it in memorial style. You're showing all of the evidence. You're filing witness statements, fact statements, expert statements early on. You know exactly what you're dealing with. You know the terms of engagement. You know the areas of disagreement. The chances are the arbitrator can make much more of an accurate assessment as to how long you need for the hearing. And then you can be more bold in your imposition of that time frame on the parties. That's my experience.
Yeah, absolutely. I mean, that seems to be the utopia view, if one can get there. Of course, the important thing is to have personally witness statements up front, have a full disclosure of what your case is, and then only have your case resolve around or evolve around cross-examination. Now, one can make a determination as to how long cross-examination may or may not take in the chest lock methodology, but I'm not in favor of curtailing cross-examination because sometimes it takes time. And sometimes depending on the witness that you're cross-examining and the difficulties and the challenges faced in the process could derail the process if you have a time limitation on it. But of course, once you run a chest lock scenario, absolutely for openings, absolutely for heads of argument, absolutely for various interrogatories. But I don't think necessarily for cross-examination. But you have to know what the case is about to get there.
Just on that point, I mean, I've seen very, very few instances where a party really has been deprived of their opportunity to get their defense across by limiting. And I've seen so many instances where cross-examination has resulted in weeks of extension. And so I think that there is a balance. I think as an arbitrator, you've got to try and get buy-in from the parties.
Yeah.
But I do think arbitrators can be a bit more forceful because counsel and attorneys, whoever they are, doing cross-examination sometimes like their own voices and they like to carry on. Don't you tell me how I will do this. I have all this planned and I'll take 3 weeks if I want to take 3 weeks. We've all heard that. Most of the time it's nonsense. And I've seen very effective cross-examination done in 10 minutes. It's amazing what you can achieve when, I had a particular matter where a counsel on the other side said, I need 4 hours to do this. The arbitrator said, you've got 30 minutes. It was a big, toys were thrown. He was done in 30 minutes, did everything he needed to do, done and dusted, no problem. So it is amazing what you can achieve when you're under that pressure.
Absolutely, but you need to know the case.
I think Abdul's got his hand up there. Abdul, do you want to come in on this?
Yeah, well, if I can start, I want to come in on this, but also just touch on a couple of points that Tim made about expert evidence. I think Tim referred to the duty of the expert being to the tribunal. That's a very if I may say so, English / sort of Australian view of the world. That's not a view that's taken everywhere in the world. In America, for instance, the presumption, the assumption is that the duty of the expert is to the parties, and that's a big issue when it comes to the difference between the way we look at expert evidence in international arbitration. We grow up in a system where it is assumed that the duty of the expert is the tribunal. That doesn't apply across all jurisdictions, and I think that's something that a tribunal has got to be aware of. Secondly, I think on the issue of early engagement, absolutely, early engagement is critical. Just agreeing basic data sets, agreeing, in your discipline, Tim, agreeing what the baseline program is. Those are basic things that can be done at the outset, which should be done at the outset to make sure that that you don't get the ships passing the night problem. Coming on then to the issue of cross-examination and the chest clock. And the chest clock again is basic. It's used now in my experience virtually all the time. And I agree entirely with Jonathan that limiting cross-examination is. I mean, if as counsel, wearing my counsel hat now, if I know I've got 4 hours to cross-examine a witness, I will get what I need to get out of that witness in 4 hours. That's my job. And important things such as not having to agree that you don't have to put every single point to the witness. You don't have to raise every single contention or argument with the witness. Helps in speeding up the process. So I think common sense from the counsel and a certain amount of flexibility from the tribunal helps in dealing with the issues that crop up when it comes to chest clocks and cross-examination, etc. I think you can impose limitations on counsel to make sure they get that cross done in an efficient way without spending weeks on cross.
Interesting point there on not putting the entire case to a witness, and that's coming certainly in the South African perspective, in the court world and litigation world, that is a requirement, is you must put the case to each witness. So how can you limit that while still affording the opportunity to challenge that witness? Is it through the requirement of having opening and closing submissions in writing so that you can see the party's case and exchange of those up front?
Yeah, exactly. I think it's having full written openings, full written closings, and also communications between counsel. If you have experienced counsel, it benefits both sides not to have to put every fruitling point in your case to every single witness, because that just drags out the process. I mean, experienced counsel would know what the key issues are in their case, what the key points of dispute are that are going to be assisted by the evidence of the lay witnesses and the expert witnesses. So you should be able to draw up, and also having things like lists of issues, for instance, again, helps you to identify what the real contentions are between the parties without having to go through the old-fashioned process, if I may say so, of putting your case to every single witness.
And again, maybe this is just for the broader panel. What role does the arbitrator have in that, in calling for that list of issues, in calling for written openings, in setting that procedure? You know, you might be. Not everyone is represented by full-time arbitration practitioners, and not in the international realm. So there's a level of experience, and you said experienced counsel. When does the arbitrator step in and say, "This is how I want it. I'm running the case this way"? At the end of the witness statements, I want written openings 2 weeks before the hearing or a month before the hearing, and I want included in that an agreed list of issues that I have to determine. That will surely limit the duration of the evidence and what is actually so. Is that a practical step that can be taken?
But proactively, I think the arbitrator should do that and is obliged to do that. When the agreement determines and the rules determines that there has to be a decision, expeditious decision, cost-effective decision, dealing with all the issues in dispute. And that lays the foundation, the groundwork for the arbitrator to do exactly that. And he has to.
Yeah.
Yeah. I mean, spot on, right? I mean, the arbitrator proactively grabs this by the scruff of the neck, calls the parties into the room and said, "Great, I think I understand this case. Am I right? These are the 5 points. If I determine bang, 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 I've resolved this matter. Are we in agreement? Yes, we are. Great. Now everyone knows exactly what the focus of the proceedings are." Neil Kaplan's big favor of early openings and the real benefit that delivers to the parties. It really calls your bluff early on in the proceedings. If you're being evasive and you're trying to duck and dive, there's nowhere to hide in arbitration. And that's, you know, we've all seen the horror stories of evasive pleading, and 4 years later, we're still running the same process. You've got an arbitrator who grabs this thing by the scruff of the neck and said, "Great. Put your money on the table. Show me exactly what your case is. Show me the evidence. Exchange that. We actually are very narrow. Guess what? We only need 2 days for the hearing." Not great for the fees, very good for the clients.
Yeah.
One of my colleagues says that arbitration is like going to checkers. You buy, you pay, you leave, you come back, you buy, you pay, leave. And that's the revolving process. So
I think that probably, this is a very interesting topic, and we could probably go on for another full day seminar. But I think I'm going to wrap up the discussion there, which we've already been going for just over an hour and 15 minutes, and I want to leave some time for questions. I think we're all in agreement that, you know, there is room for improvement in how it can be done, and there are certainly practical tools available to arbitrators who are willing to be a bit more proactive in ensuring it. And a large responsibility also lies with the legal representatives and counsel in making sure that they're actually adhering to best practice and distinguishing arbitration practice from court practice. They're 2 distinct disciplines, both aimed at resolving disputes, but in fundamentally different ways. Before I open it up to questions from the online audience, and there's been a number of questions on the Slido app. But before I open it up, if I could just ask everyone to get their Slido apps open again. We've got a few more polling questions, and hopefully we'll see some insights from the audience following this discussion. The first question: in your opinion, would chess clock hearings place too much emphasis on efficiency at the expense of a fair opportunity for the parties to present their case?
Okay, I will start with the questions.
So it's here it comes. There's the. It's very interesting. I mean, it's quite close there. There's
Sure.
you know, almost split evenly down the room that limiting hearing times through it puts too much emphasis on efficiency.
Sure, interesting.
It was very interesting.
I think there's one point on that chess clock. Maybe a misconception there as well is quite often you can have chess clock where you can ask 4 times. So you can say, I need 1 hour, but you're given 1 hour. End of story. So it's not as though the arbitrator then says, oh, you can only have 15 minutes. Normally arbitrators are quite engaging on the point, and so time is allocated, but the point is you're not getting any more than that. And I think that's one of the key points there is that there is an effort to try and get.
I suppose this is also needs to be seen in context, because a pleading style, if we've done pleadings and you've got witness statements, you don't have written witness statements, and you're now placing a limitation on the parties, then yes, it would be a curtailment of the ability to present your case. But if seen within the context of all of the other things that we've discussed this evening, memorial style pleadings, early engagement of experts, written openings, then the issues are a lot narrower. So I suppose the take home on this question is it depends.
Absolutely.
And the answer is probably no, provided you've taken a number of other steps prior to the actual hearing itself.
Absolutely. Must know what the case is about.
Interesting result that.
50-50.
Second question, and maybe this just leads into it. Does directing more memorial style pleadings where the statement of claim is accompanied or the pleadings are accompanied by all evidence that is going to be relied on, is it more efficient?
Oy.
I think we've got one vote so far, or unanimous decision.
Can we then have unanimous consensus in arbitration? Well, 97%.
This is very interesting, because in practice we often seen a reluctance to go towards memorial pleadings.
Well, that was my question, just because I'm not usually not in the room where that's being discussed, but the reluctance comes from the claimant normally or the respondent?
I think it comes from the
Both.
parties.
Do you know, I think one of the reasons why we also see it in South Africa, so the AFSA domestic rules are not really created for memorial style pleadings. You've got to file your statement of claim right up front when you file your request for arbitration, which almost means that memorials is impossible. So I think that has a lot to do with that in the domestic context, but where we're hoping to go in the international context is that we're playing the same game. And that is often why you have your request, you have your procedural meetings and the like, and then you are directed to file your pleadings once you've reached agreement as to what is most effective.
I mean, I'm really surprised by that, because I'm yet to have all parties jumping at the opportunity to file memorials. So
Big upfront cost.
it is a big upfront cost, and that is probably a big mitigating factor on this, is that you really are investing in your case up front to save on the back end.
That's right. Upfront cost now, save on the back line.
Yeah.
Okay, and then the final question, and we've really touched on this one, but limiting the ambit and extent of cross-examination, if done appropriately, does not result in an unfair process.
Who would do the limiting?
The arbitrator.
Well, not necessarily. I mean, the parties could agree.
Well, the parties could agree. Again, it's probably a bit of a nuanced question, because it's going to come down to, is there agreement on the issues? How much has to be challenged? I suppose the difficulty comes in if you're having to start make credibility findings on witnesses, and and then you do need a bit more free rein in the cross-examination realm. But so again, I don't think it can be a blanket limitation up front to say you're limited to this many minutes per witness. But maybe, Jonathan, you, as you stated, an upfront indication of at a second pre-case management meeting prior to the hearing where counsel give indications for witness X, I require 3 hours of hearing time to cross-examine and you know, a bit more. We've talked about proactivity, but proactivity from the legal teams and counsel in actually giving detailed consideration to how much time they're going to require.
I also think the struggle to find a counsel who won't engage with the parties. So if I say you've got 1 hour to do this and the party wants 4 days, the arbitrator will say, why? Talk to me. Why do you need 4 days? Explain yourself. And there's probably going to be a bit of bartering going on. Then you find some consensus somewhere in the middle. It's very, very seldom that you have an arbitrator not engaging with the parties and saying, I believe you only need 15 minutes. I'm not engaging any further. Good luck and go. I mean, that's walking into reviews.
Yeah. Okay. That's the end of our polls. Are there any questions for the panelists? I think we've got Abdul. There we go.
Yeah, can I just say, I mean, I think on that last point that Jonathan made, in my experience, I mean, the way this generally works is that the parties agree, you know, we've got 10 hearing days for this matter, and they'll split the time evenly, and it's up to you how you spend your time. If you want to spend 4 days doing your opening and then half a day doing witness and half a day doing closings, that's up to you. That's it. I mean, it's really up to the parties to decide how they want to spend their time. And that's the key. But again, I agree with Jonathan that a good tribunal is going to be engaging with the parties to try and reach some sort of consensus or agreement as to, well, you say you want 4 days, you say you need 6 days. You know, why do you need 6 days? Can we agree on 5, for instance? So that's generally my opinion. That's how it works.
We've got 5 minutes left, and I don't want to deprive anyone from cocktails, food, and wine and a social time. So let's maybe take a few questions. Otherwise, I'll pick some from the Slido Q&A. Yeah. Anyone in the room?
Thanks. Maybe to Abdul and Henk as the arbitrators, but you know, to what extent does an arbitrator's duty to procedural efficiency extend in a situation where at the first procedural conference, the arbitrator says, okay, you've got a 2-week hearing in a year's time. And then one of the party's legal representatives says, sorry, I'm only available in 2 years. How do you sort of balance that situation?
Counsel and availability.
Yeah, look, I mean, if you as an arbitrator make yourself available, you have to give a declaration that you're available and within a reasonable time you can deal with the matter.
Yeah, I think it's the counsel.
Yeah,
So
counsel.
legal reps aren't available.
You're setting timetables to suit the legal representative's availability. And that maybe goes down to the very first point that Jonathan made, which is it's the parties who are being served here, not the legal reps.
Absolutely.
And does the tribunal then step in at that point and say, well, sorry, you know, now you're striking a balance between the party having their preferred counsel versus that party's counsel not being available for 2 years. I mean,
That's problematic.
I'll defer to the arbitrators.
The principle is, of course, you're not entitled to a specific counsel, but you're entitled to counsel.
Yeah.
That's the general principle of law. And if there is prejudice because of the non-availability of counsel, well,
Get a new counsel.
something has to be done.
Abdul,
I agree entirely with that. I think, I mean, you always have to be careful in not overstepping as the tribunal. But if a party is saying to you, well, I'm not available for another 2 years, or their party representatives say you're not available for another 2 years, then you encourage the party to go and get a different counsel so they can hear it within a year or however long you think it should be.
another question? At the back there.
Is it on? Okay, sorry. So my question is, does any engagement of your experts, and I'm going to try to be specific in this instance, of like your delay experts, in instances where they're taking very different approaches. Say you've got a delay expert that's taking your time slice approach or rather methodology, and the one takes as planned versus as built. Does any engagement in such instances really help? Because
I'm thinking you're going to come at a different outcomes anyway.
So I think it still would help, even if each expert's hell bent on their method, because at least they know that at some point they're going to have to deal with the other method because the question's going to come to them. And so in there, if you have an early engagement, they can agree to disagree on which is the appropriate method, but still efficiently come at the issue from adopting the other experts' assumptions. So you still get one submission that's answering the same question and they speak to each other, and you don't get the ships in the night situation. And ultimately, if those experts can't agree a compromised approach to it, then in any event, each expert's going to have to double their analysis if you do 2 analyses. So you may as well set about doing that from the beginning. There's nothing lost.
It's just related to that question, maybe Tim, and maybe then I can also get everyone else's input on this, is tribunal appointed experts. I don't think I've ever seen it actually being utilized in practice. Is that a method to shortcut things or not, especially in circumstances where the other 2 experts are going in opposite directions from the get-go?
It could be, but of course it's by way of party consent, and it's an additional cost in the process.
Yeah.
And I've never seen it.
Yeah, I mean, maybe I haven't been around long enough. I haven't really come across it. I know it does happen. I guess it could be beneficial. I guess the perception would be that the arbitrator is in some way delegating his decision to someone. It's all too complex. So I guess from a party perspective, I guess you'd be asking questions. Why, I've already paid for an expert, why am I paying for another one? And is the arbitrator somehow shirking his responsibility to understand the matter? So I don't know, but I know it does happen, and maybe a bit more in the international space. Abdul, I'm sure you've no.
No, never come across it. I mean, I can imagine. I can imagine that it may come up where essentially you have pretty much sort of non-controversial issues. So quantum is one where I can think, okay, it's a question of crunching the numbers, and rather than having 2 different experts doing that, you can agree to have a single joint expert who will basically go through numbers and try and, for example, find evidence or substantiation of costs or whatever. I can imagine that being a circumstance in which you'd have a single joint expert, but I've never come across it. And if it involves anything that's even vaguely controversial, I'm sure the parties will insist on having their own experts.
I mean, just on that point, so Article 23 of the AFSA rules provides for the appointment of tribunal experts. There's no requirement of agreement between the parties. All that's required is the tribunal needs to consult with the parties and hear their versions. The tribunal then can decide to appoint an expert to assist the tribunal. And sometimes where this is helpful, particularly when dealing with US-style proceedings, where you've got 2 hired guns on either side, there's no duty to the tribunal to assist the tribunal. The perceived duty is to your client. Then an expert may be helpful for the tribunal in trying to distill what's actually going on here. But you're absolutely right. It's not a very common thing, but the rules do provide for it.
And just as another point on that, I know in the German system, in the German domestic system, my job doesn't really exist. It's all tribunal appointed experts, and they have a panel of experts, and depending on the matter, they'll pull them in, and the party appointed expert role is very limited in the domestic jurisdictions in some. I couldn't comment. Yeah, I don't have enough experience in the yeah.
Question. Is the efficiency like?
Yeah.
Appointed expert?
Yeah, I was just saying. Yeah, I mean, I can imagine it's knowing the Germans, more efficient. But yeah, so I don't know. But I can imagine it just takes a couple of documents out of the proceedings as well. So it's just less. I guess there is one less thing to deal with. So I can imagine it's more efficient. Whether the parties feel like their case has been properly considered, that's a different question. But I can't imagine it being slower.
I think we're to qualify that it's and under civil law jurisdiction, it's a much more inquisitorial approach than it would be under common law jurisdictions and our adversarial approach.
Can I just add to that?
Sure.
Should we be looking at maybe in the long term, either restricting the use of the High Court rules in arbitrations altogether, or perhaps even abolishing them in the interest of efficiency and giving effect to what an arbitration should really be?
I think that comes down to the parties' agreement. Ultimately, at the end of the day, arbitration is a contractual mechanism, and it comes down to what the parties agreed. I would hope that no arbitration practitioner writes into an arbitration agreement the High Court rules as the governing. But we do see it time and time again, and as the governing set of rules. And quite frankly, it's got no place in arbitration at all.
But I think a strong arbitrator there should draw the line and say, we are not playing soccer with rugby rules.
Yeah.
And we're going to use a proper set of arbitration rules.
No, I agree. I don't think you can ban it if the parties, that's what they want to do. And it comes down to Jonathan's initial point. And, the arbitrator's got to give effect to what the party's agreement is. I think, all of us disputes practitioners should have a word with our colleagues in our law firms who do the drafting and just bash them over the head if they include anything that says High Court rules in arbitration.
Yeah, absolutely.
You would hope those arbitrators will get fewer and fewer appointments as we all evolve.
Yeah.
But we're not there yet.
Can I just come in on that? Because I'm an arbitrator now in a matter from AFSA, domestic arbitration, where the parties had, before coming to AFSA, already agreed on High Court rules. And it's soul destroying because you just can't get this thing moving. And despite in the first pre-arbitration meeting imploring on them to agree not to use them, they insisted. So you're stuck with it. There's nothing you can really do. And it's we've just closed pleadings now, and it's months since this thing was referred to me. There's nothing you can do. But just to get back to the discussion, it seems to me that listening to the discussion, and from my own experience as an arbitrator and also as a representative, a legal representative in arbitrations, that it's a no-brainer, really, that the front-end system that you're speaking of and memorials and that is the way to go. Because if you think about it, you're going to have to incur the cost of the preparation for the arbitration anyway. If it's a genuine arbitration where people are genuinely trying to resolve a dispute. So you're going to incur those costs anyway. You might as well incur them up front so that you have less back-end costs, which are more costly, because now you've got the cost of the arbitrator's time, venues, transcriptions, and all of those kinds of things. But what is also very frustrating, particularly when you're a legal representative, is coming before arbitrators who are appointed either by AFSA or the association or any other institution who are not really trained in these new systems, this front-end system. And I think, for example, the classic examples are very old senior counsel, and I don't count myself in that. Very old judges. We forget sometimes everybody wants this ex-SCA judge, but you forget that it's been 15 years since they retired and they're about 95 in the shade. And so the problem with them is they might be very clever people and they've got years and years of experience, but they've been brought up in a regime which is based on the adversarial system, a strict adversarial system, where a judge is told to stay in their lane, and they are not trained in the new systems, and they're not trained necessarily in arbitrations. And I find that a problem when the appointments are occurring by the institutions I'm not saying about the matters, I'm not talking about matters where the parties have come, say, to AFSA and said, we've agreed on X, because there's little you can do about that. But when the institutions are appointing where the parties can't agree, they should really focus on appointing people who've done the courses, the Association of Arbitrators course, teaching all these new systems. Because the older guys, and sometimes even younger guys who've not been involved in arbitration, just don't know about these things. Memorial style pleadings, what are you talking about? They have no clue about front end systems.
I suppose that's it's an interesting insight, and also to an extent the arbitral institutions, the nominating bodies, taking on a bit more of a gatekeeping approach here to make sure that they maintain panels that are suitably trained and suitably set up to administer that institution's rules, rather than having a lengthy panel of just, people who might have been very good lawyers, judges, high court practitioners. And we talk about that inherent bias, but if that has been the background and that is the approach, you will interpret the rules in a narrow manner and interpret them to mean I want pleadings, rather than in the broader, my duty is to resolve this as quickly as
all that probably goes to training, academic training, and practical training as to how to run these things.
Yeah.
That's why these sessions are so important.
Yeah.
We also do the arbitrator training. Edwin Glasgow from the court runs those really, really intense personal sessions with focusing on our experienced arbitrators to make sure that we're aligning with international expectations. It is a journey. We're getting there slowly.
But I like Edwin's approach, in where he got quite annoyed with us the other night and saying, stop calling it alternative dispute resolution, because we are not an alternative anymore. We are now the dispute resolution methodology. So just call it dispute resolution, forget about the alternative. That doesn't exist anymore.
Yeah. I think I'm going to draw things to a close there. Sorry, Svetlana.
Just one last question. While I have all of you here, what is efficient case management? What is the expectation of the counsel, arbitrator, and the expert?
What is the role of case?
What is the
effective case management?
What you want to see while you're counsel, arbitrator, or expert?
I think from my side is putting in place the systems, whatever they may be, that will give you a progressive narrowing of the disputes and a real narrowing of the disputes. Again, it comes down to the nature of the dispute. One of the opening things we said was you're going to have a very complex matter for not very much money and a very short interpretive issue for a large amount of money. Really understanding the issues at play, that's the starting point, and then agreeing a procedural order, that all important procedural order number one.
Yes.
And that, I think, Henk mentioned it at the beginning. Normally, it takes the view, takes the approach of a pre-trial minute. You're seeing it being borrowed from the High Court rules, and it's a minute and an agenda that gets talked about, and then that gets incorporated. And I'd like to see a lot more proactive steps from an arbitrator's perspective, saying, this is my procedural order. This is how I want to run the process. Parties, give us your submissions on this, and this is what we're going to be discussing at the first case management meeting, and a shepherding towards how the arbitrator wants to run it from the outset, because ultimately he's going to be the one, or she is going to be the one, making the decision at the end of the day. And it's in their interest, and it's in the party's interest, that by the time you get to that final hearing, the issues are as narrow as they can be. All of the information is available, and you can do that through putting in the correct steps throughout the process.
The scary thing about the process is that everybody teaches you about arbitration, but what they don't teach you is when the parties phone you and you sit down at your first pre-arbitration meeting, your first procedural meeting, what happens there? AFSA Domestic does give you a one-page about some of the issues that you should deal with. Other institutions and ad hoc arbitrations don't give you that. So you're not a fresh arbitrator stepping into the matter. You have no idea often what to do in the first meeting. And that's something that you learn through time. And no one tells you about Kaplan's book. No one gives you the LCI training. A couple of years ago in Cape Town, University of London came out at the Africa Arbitration Week and sat with the day. And the big thing that they dealt with is procedural orders. What do you want? How do you start? And the ICC has a practical procedural training course, and no one else does it. But that's what we need. Train the arbitrators upfront, let them know what they're supposed to do, and that's where we need to go.
Okay.
Thank you very much from my side.
Yeah, thanks, thanks everyone. Thanks to our panelists. Sorry, Abdul, I forgot your hand again. I
No,
apologize.
it's okay. It's okay. It's okay.
I apologize. Yeah, Abdul, any input on that?
Well, no. I was going to say, I think one thing that we haven't touched on, I think, is potentially, it's slightly left field, but I think when it comes to the appointment of the chair of the tribunal, when this is in the gift of the institutions, I think it's important that the institutions get the right fit for the chair of the tribunal, because the chair has a really pivotal role in running the arbitration, and it's important to get the right person for the dispute. That's just my contribution at that point.
Thanks, everyone. Drinks and canapes will be served in the foyer. And thank you to our panelists. I for one found it very interesting, and I hope you all did too.
Andrew, thank you for you.
Yeah.
Yeah.
Great.
Thank you very
Thanks.
much, Andrew. Thank you. Thank you.